we do have a major Supreme Court decision to talk about. Let's go to Paula Reed now.
Yes, Jim, this is one of the biggest cases that we've been watching this term. It deals with gun rights, and here the Supreme Court has upheld a law that bars domestic violence offenders from owning firearms. Now, a couple years ago, the Supreme Court really broadened the definition of the Second Amendment, and now they've been fielding additional questions about exactly how far the Second Amendment extends. But here they have upheld a law that bars someone. In this case, it was a man who was indicted on domestic violence charges. He had a protective order against him, and this case dealt with whether it was constitutional to bar him from owning a firearm. And here the Supreme Court has upheld that law, banning domestic abusers from owning guns. I mean, this is a major Second Amendment ruling from the High Court, and really one of the biggest cases that we've been watching this term.
Yeah, Paul, I mean, this is a major decision for gun control advocates, correct?
Absolutely. It's a big win for gun control advocates. It seemed to be leaning that way during oral arguments. If you listen to the questions, if you listen to some of the skepticism that some of the justices had, but this is a significant win for them. And again, like I said, 2 years ago, the Supreme Court really broadened the definition of the Second Amendment. Now they've been fielding additional questions about who can and cannot potentially own a firearm. So here, a big win for those seeking to restrict, in some cases, the right to own a firearm.
And Ellie Honig is with me. Ellie, I do want to ask you very quick. I mean, we shouldn't just say gun control advocates. I mean, victims of domestic abuse have been watching this case very closely because, I mean, the idea that, you know, people who are abusing their spouses or loved ones or what have you, having the ability to own guns and the government not being able to stop that from taking place. I mean, this was obviously a significant case.
It's a really important decision. It's a rarity. It's actually a narrow reading of the Second Amendment. The decision, by the way, I should say, is written by Chief Justice Roberts. It's an 8-to-1 decision. There's a couple of what we call concurrences, meaning justices who agree for different reasons, and there's one dissent from Justice Thomas. But you see an 8-to-1 decision here that says it is okay. Federal criminal law can say that a domestic violence abuser can be denied a firearm. You can keep guns out of the hands of people who are subject to domestic violence restraining orders. So we didn't know this one was legitimately, you couldn't tell which way it was going to go. They've taken a narrow view of the Second Amendment, and they've upheld this restriction on firearms rights.
That's fascinating. And Deborah and Akil, our legal scholars, constitutional scholars, are back with us as well. Akil, let me go to you first. I mean, was this a surprise to you based on the oral arguments? What do you think?
So great to be back. Yesterday, I very foolishly, perhaps, made the prediction on your show at 10 a.m. And I said, I thought Rahimi was probably going to come down, upholding the government's position, reading the Second Amendment more narrowly. I predicted it would be an opinion, most likely by the Chief Justice. I said that I thought my friend Clarence Thomas would be in dissent and that there might be daylight between Thomas on the one hand and Justice Barrett, for example, on the other, because I was asked a question about that. And it was silly for me to make that prediction, but it turns out that's what happened today.
Not so silly.
And just to remind your audience of the significance of this, as Ellie just said, this is the first major opinion in the modern era that is reading the Second Amendment narrowly and ruling against it. The three big cases in the modern era before this were a case called Heller, in which Justice Scalia read the Second Amendment broadly over a dissent by Justice Stevens, for whom Deborah clerked, and then a second case, and my judge, Stephen Breyer, a second case called McDonald, where per Justice Alito, again, a broad reading of the Second Amendment, and a third one just recently, a case called Bruin, where Thomas wrote for the court, and now he's in dissent. This is the first. So three big wins for the Second Amendment. This is the first time it's being construed more narrowly. And so now actually it's a ball game.
Yeah, Deborah, I mean, can you pick up on what Akil was saying there? Because, you know, obviously there has been a broad interpretation of the Second Amendment coming from the High Court in recent years. But my goodness, having a law that bans domestic abusers from owning guns, that sounds like a common sense to a lot of Americans out there. And if the Supreme Court had gone the other way, I just can't imagine what the outcry would have been. That would have been something else.
Yeah, so it sounds like, and I'm sort of reading the opinion here as it's coming down. We've got 103 pages to sort through. But it sounds like it was roughly common sense to the justices, too, at least by a vote of 8-1. I do want to make just a couple of points about this. Akhil is right. Of course, Heller, the first major case by Justice Scalia that recognizes an individual right to bear arms, is supported by the Second Amendment, contrary to what it had always been read by as the Supreme Court previously. But even Heller, even Justice Scalia in Heller says there are limits on the right to bear arms. And interestingly here, the majority, again by a vote of 8-1, which is really a remarkable amount of consensus on this court, says actually when Justice Scalia and Heller said there are some exceptions, he meant it. So that the court begins to say, look, you don't have to. The standard Justice Thomas had announced in Bruin caused an enormous amount of confusion in the lower courts, a cascade of litigation across the country challenging different gun laws because it seemed to suggest that you had to have an identical law on the books at the founding era for something to be upheld today under the Second Amendment. The court here in this decision really seems to be backing off that extraordinarily broad and almost inconceivable view, saying more than just, these can be regulations that are more than just those that were identical to those that existed in 1791. Here, the court uses some language relevantly similar. I'm not sure this is going to cure all of the confusion in the lower courts, but it is certainly pulling back from the extreme position that Justice Thomas's opinion in Bruin had staked out.
And Paula Reed, I want to go back to you in case you have an update on this very important case coming down from the High Court today.
A hugely important case, Jim, and we're having a chance now to read through the opinion. And here, Chief Justice John Roberts said that the court had no trouble arriving at this decision. At least 8 of them did not. He wrote, quote, "Our tradition of firearm regulation allows the government to disarm individuals who present a credible threat to the safety, the physical safety of others." Now, during oral argument, the Solicitor General argued that a woman who lives in a house with a domestic abuser is 5 times more likely to be murdered if he has access to a gun. So this, again, one of the most significant cases that we have been watching for this term. There's still a few other big ones, but it's notable that the Chief Justice said here, look, this wasn't too difficult for us to come to this conclusion. Jim, we know they have other outstanding questions, the Trump immunity case, a big outstanding abortion case, or perhaps they may be having a little more difficulty reaching consensus.
Yeah, I mean, the Chief Justice saying our tradition of firearm regulation allows the government to disarm individuals who present a credible threat to the physical safety of others. I mean, that is the Supreme Court of the United States trying to apply some common sense to a very important issue in all of this. And Shermichael Singleton, you're on set with us as well. I know you are a staunch Second Amendment supporter. What's your response to all this?
Yeah, initially I'm a bit skeptical with what I've been reading thus far. I was attempting to read through Justice Thomas's disagreement here, his dissent, but I wasn't able to finish it in totality. But I think at least a bit of what I read, I think I would agree with. I own a firearms company, and one of the first things that come to mind as we've seen, Jim, a huge increase in African-American men owning guns. I was looking at the Innocence Project website, and they were showcasing the large percent of black men who are falsely not only accused of domestic violence, but often found guilty of domestic violence, and years later discovered that they were actually innocent. And so I wonder, if you're in that position, how in the world, based upon this decision, does a court protect your constitutional right to keep and bear arms? And that's something that I did not see in what I've read thus far.
But, I mean, obviously there is the overwhelming, it sounds like the Supreme Court is saying prevailing view that the public has to be able to protect the victims of domestic abuse. And you can't have domestic abusers owning firearms, going to the gun store and picking out some guns.
On its face, I would agree with that. Obviously, you want to keep individuals safe from folks who want to cause harm. But I also think you have to protect people's rights to keep and bear arms, particularly individuals who have a higher and increased propensity of being falsely accused of domestic violence, of being found guilty of domestic violence, and then later on being found innocent. And you see that in higher rates with men of color, specifically black men. And that concerns me with the higher number of black men who now own firearms.
You're talking about a very big issue, which is just the unfairness of the system that we have in this country that unfairly targets African Americans. There's no question about that.